Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stock repossession, and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.
Hello, you're welcome to today's show at Heritage TV, and it's the Legal Hour show with BWF Solicitors. I am your host, Vicky Newton. Today's topic is, what do I do when an application is refused? Be it an administrative review, appeals, and judicial reviews. You may be asking yourself, when is putting in an administrative review effective? Or are appeals the most effective? These and many more questions will be answered by our resource person on today's show, who is in the person of Mrs. Champong, a solicitor and partner at BWF Solicitors. May I also remind you that this program is proudly sponsored by BWF Solicitors, Victon Estates, and Eagle Heights International School. If you would like to contribute to this program or ask your questions, you can do so on our Facebook and all social media handles, YouTube, and we will be able to pick up those questions for Lawyer Eunice to answer your questions. If you prefer to call me live on this program, the number to call is 0744 8619 711. The number again is 0744 8619 711. Lawyer Eunice Achampong, you're welcome to the Legal Hour show on Heritage TV. How are you doing today?
I am doing well, and before I forget, I have to wish my lovely husband a happy birthday. So, this is
Ooh.
my husband Augustine Echampong. I wish you a happy and a blessed birthday. I pray for more of God's wisdom and direction, and for His favor to be upon you, for Him to increase you in knowledge and understanding, and for Him to extend your territory. I know there is so much you want to do, and I pray that the Lord will continue to bless the plans that you have and to make your plans prosperous. So, on this day, I wish you a happy, 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 and a blessed birthday.
Oh, and we also thank you as well for always, taking care of the kids and making it possible
Yes,
for you to come our way every Saturday to educate us
definitely.
on legal matters. So with that, we also appreciate him so much. Behind the scenes, he's helping a lot. So happy
Yeah.
birthday, Mr. Achampong. Right, Lawyer Eunice. And before Lawyer Eunice gives us updates, I would like to say that whatever is going to be discussed here is for information purposes because questions being discussed may be different from your personal circumstances. So we advise that if you fall into this category or you need further advice before making this application, do not hesitate. Contact Lawyer Eunice and her team, and they will take it from there. So don't take what I discuss here as your final decision to go ahead with an application. But I will advise you contact Lawyer Eunice and her team to specifically look at your case and find ways and means to help you with your application. So back to you, Lawyer Eunice. Updates, please.
Okay, so just before we go on to our topic, I know that there are still so many people that are obviously asking the question about this Akisenya case and what
Yeah.
it is all about. And I know that a lot of people are looking forward to a decision so that they can go ahead and put in their EU settlement derivative rights applications. So as of now, they haven't made a decision, which is the Court of Appeal hasn't yet made a decision as to the case of Akisenya. And of course, we know that it was appealed to the Court of Appeal by the Home Office because they believe that the High Court decision to make someone who previously was on the derivative rights route and then switched to a leave to remain route should not be eligible to then apply onto the EU settlement scheme. And it's something that is very clear under Appendix EU that if you already have an existing leave to remain, you cannot therefore switch to EU settlement scheme application. And so, of course, the Home Office has a point because it's already within the immigration rules under Appendix EU. And so, of course, this is something that a lot of people are also hoping that the Court of Appeal will make a decision which will be favorable to them because previously, under derivative rights, you did not have that route to settlement or you wouldn't be able to apply for indefinite leave to remain. So usually somebody who was on that route will either have to do another 5 years until their 10 years is up to apply for a long residence, which is 10 years lawful residence application, or they would then switch on to the leave to remain route to be able to apply for indefinite leave after that route has ended. And so, of course, this was a good news to a lot of people when in 2019 the government announced that all those who have derivative rights can now apply for settlement. And so Ms. Akinsanya took her chances and made the application onto the EU settlement route, even though she had 2.5 years after switching from her derivative rights route, which was ending, to a 2.5 year route. And of course, the application was refused, and they decided to go ahead and lodge a judicial review in that case, and it went all the way up to the High Court, and of course, the High Court made a decision in favor of Miss Akinsanya. But now the Home Office is disputing that and has lodged their permission to the Court of Appeal. And so we are waiting to see. And a decision that is going to affect quite a number of families will definitely take time to be thought through and assessed before it comes out. So we are watching the space, and hopefully in the next few weeks or months, they should make a decision so that we can broadcast. And of course, if it is in favor of Ms. Akinsanya and other people in her case scenario, then of course they would give a period of 6 weeks for people to make the application before anything else is decided. And so, of course, I think that once a decision is made, we'll definitely let viewers and those that are watching us from wherever they're watching us to also know. And I think that in regards to what is going on in Afghanistan, and we all can see from the news that it's terrible. If you watch the Al Jazeera channels and Sky News, I mean, you can see really that there are people who are in dire situations. And when you listen to first-hand experience of how it is like for them, it is terrible. And I had one person come and see me last week, and it's really sad, and it's something that I believe that if something can be done, it might have to do with re-educating the people, because it is a civil war that seems to not end ever, and it's been going on for years. And right now we have the Taliban who are saying that they are going to make sure that by next week, which is the 31st of August, they are going to stop the West, which is the US, the UK, and other countries that are seeking to evacuate their citizens from doing so. And it's like a threat. But we are hoping and praying that at least they can evacuate as many people as possible before the Taliban take absolute control. And so the Home Office has put on their website that, of course, if you are a British national, or you are somebody working within the media, or you are somebody who obviously works for a charity and other groups, and you believe that you are entitled to be evacuated, you can contact the consulate and then, of course, make your interest known. And then you have those that are British national family members who live in Afghanistan. And of course, if you have made applications for your family members to join you during this terrible time, they are also people that have been put on their priority list, and therefore they will consider people on those application lists in terms of the evacuation that they are doing right now in Afghanistan. So that's just a bit of update in terms of
I know if we say we are going into this Afghanistan thing, the evacuation is going to take over the whole show. But just a quick one. For those who haven't regularized their stay, or have their case pending in the Home Office, and have family members, how do they go about? How can they try to get their family to the UK? Because they can't go there, get them to UK, and I don't know how they can also try whilst living in the UK to get their family to join them.
So yes, as I was just explaining, so for instance, if you're a British national and you have family back in Afghanistan, of course you would want to put in an application for them to be granted entry clearance into the UK, and the usual application will be like a spousal application, or if you're a British national yourself here in the UK, you would want to make a British citizenship application for your children who are back in Afghanistan. And so, of course, if that is the case, then you want to make sure that as much as possible, you put in those applications, because uh, we are hoping and
Hello,
praying
Eunice,
that.
if you term someone as a British national, someone who
Mhm.
doesn't have a stay, hasn't, got they haven't been able to regularize their stay, they are not British national. Am I right?
So they would usually have like refugee status, because most Afghanistans that come here are fleeing the war, and so they would apply for asylum as soon as they get to the UK. And so most of them would have refugee status anyway, and they too are able to make an application for their dependents to join them here in the UK. So whether they are British nationals or they have refugee status,
Right.
they all are able to apply for their dependents to join them here in the UK. So it's not
All
as if they don't have any rights whatsoever to make applications for their family members to join them. So yes,
right.
there are applications available to them to obviously make their family members join them. And that's another good thing, because of course you will have many more people fleeing Afghanistan, whether it is through the evacuation that the UK is doing, or they themselves will even find their own way to the
Way.
UK. And of course, if they do and they have family members here, I know that of course the UK is not just going to turn them away, because they have made some allowance for those who have family members here to be able to then join their family members. And I think they are looking to receive about 20,000 Afghan citizens in the next few years. And so they've even said that they are willing to accept 5,000 Afghan citizens in the first year. So that's a good thing.
Reassuring to hear that.
Yeah. Yeah.
Yeah. Okay. Right. Going straight into today's topic. What can one do when an application is refused? With administrative
So
review, appeal, and judicial reviews.
So I was going to say that this is a broad topic, because, of course, there are so many people who would find themselves in this situation, especially if your application is refused. And of course, you have the option of reapplying. And so, if you are reapplying, then of course, you want to also address the reasons why it was refused. But then reapply may not always be the best option. And that is why sometimes you might have to look at the other options that are available to you, which includes administrative review, or saying to yourself, do you know what? I want the courts to actually be a third party to this application that I made, and they, being a neutral person, may have a different point of view from the Home Office. So I would want to go and lodge an appeal with the court. Or you're saying that I don't have that right of appeal, and I haven't given the right of appeal. So the only other alternative would be judicial review. And so, of course, if you are looking to have your matter looked at by a third party and you don't have a right of appeal, then you know that you have judicial review. But if you think that it is a slight issue, or it is an issue which you definitely could easily refer the Home Office to and say, this is what was presented. Maybe you didn't have sight of this, and therefore I meet all the requirements. Could you
Okay.
please grant me my visa or my leave to remain? That's when usually people would go for administrative review, because it's going back to the Home Office to basically review their decision and to make a new one. So yes, this is quite a broad topic, and I know many people would usually find themselves in one of these categories.
Okay. All right. Right. Laura Eunice, the questions have started flowing in, but I think you've gone into what the administrative review is. And the next question is, are appeals the most effective remedy when an application is refused?
So when it comes to appeals, most people would believe that they would have a right of appeal if an application is refused, but not every application would warrant or would give you a right of appeal. So if you look at our Immigration Act 2014, which came into force in March of 2015, it gave the courts new powers in regards to what appeals it should hear. And that has been implemented in our Nationality and Immigration and Asylum Act 2002. And so, of course, now it says that the only appeals that can be brought before the court is to do with those that have protection claims. And when we talk about protection claims, that includes people with refugee status, or who have made refugee and asylum applications or humanitarian grounds applications, and they have been refused and they want to appeal. And it also includes those that have made human rights applications. So either that you've made an application for your family member to join you, or you are making an application for you to continue to remain in the UK with your family member, or even for you yourself as an individual to remain in the UK based on your private life. So you have all of these applications that would warrant or give you a right of appeal. And then you also have those that are EA nationals or EA family members who also previously had a right under our immigration regulation 2016. And of course, they now have that right under the withdrawal agreements that the UK signed with the EU. And of course, that warrants or gives those people who make applications under the EU settlement scheme a right of appeal. And you also have those that are either British citizens who may be deprived of their citizenship, whether they have used false documentation or made false representations. They too, when their citizenship is revoked, they too have a right of appeal. And of course, if you think that maybe your leave was cancelled without the right information, and you would want, of course, that you can redress the decision that the Home Office has made to cancel your leave or cancel your entry clearance, these can also warrant an appeal if you are a family member of an EA national, or yourself, you're an EA national, or you've made a human rights application. These would definitely warrant an appeal. And of course, you would rather exercise your rights to appeal so that at least a third party, such as the tribunal or the court, will be able to then make a decision based on the evidence that you have given, and then of course they go from there. So I think that sometimes, a lot of the time, people believe that sometimes it might be a long process to go through appeal. Rather than go through appeal, they would rather put in a new application. Yes, there will be circumstances where making a fresh application will be the better option if, for instance, it is saying that you didn't provide a certain document and you know that you didn't provide the document, and so you want to be able to make the fresh application and then provide that document to them. But when you've provided everything that is necessary to them and they are still refusing the application, and you know that they are wrong, of course, if you have a right of appeal, you would rather exercise that right of appeal rather than to make a fresh application. And with a fresh application, you would be spending the same amount of money that you spent on the application beforehand, because the only refund they make is when you've paid an immigration health surcharge, which we call IHS. So if you were previously refused, they would refund you the IHS. But apart from that, the application fee is not refundable. And so you would still have to pay that application fee again when the application is refused and you have to make a fresh application. Whereas with the court, you are paying for the court fee and then obviously for legal representation. And of
Okay.
course, you want to make sure that you have made sure that you have gone all the way to make sure that everything that is provided, um, was provided for the application, is also provided to the court, and they also have a right to look at fresh evidence when necessary. So if you are being dealt with by a solicitor, they would let you know what further evidence to provide in terms of an application, either for some family member to join you, or if you are here in the UK, what evidence is needed for the court to then look at in terms of making their decision when an appeal has been lodged. So
Okay.
sometimes it might seem the best way to do a fresh application, but when you have a right of appeal, definitely go for that.
Right. Okay, so Lawyer Eunice, with the judicial review, when does it become necessary to lodge permission for judicial review?
So usually people who would go and lodge permission for judicial review are people who may not have a, a right of appeal. So for
Right.
instance, if I was making an application, and for instance, I made an application for, let's say, a student visa, for instance, and
Mm-hmm.
I've previously made applications and it's all been successful, and this particular one, it was refused. And
Okay.
maybe they said I provided some sort of documentation which was not genuine or was false or whatever it is. And with those applications, like student visas and skilled worker visas, those don't carry a right of appeal. So, of course, if you have made an application and it's refused, you either have the right to administrative review, which is to take the home office back on and say your decision was wrong, and
Yeah.
therefore review your decision and give me that right to be able to have my studies completed or whatever it is. Of course, if you go for administrative review and you strongly believe that they are likely to refuse it again, you would be looking to do a PAP, which is a pre action protocol. It is sort of
Right.
like a warning to the Home Office that if you don't change your decision, I will be taking you on to the courts. So that is a pre-action protocol letter. You make your submissions why they should change their decision, and of course you argue your case with the law and the rest of it. And once you've done that pre-action protocol, most pre-action protocols will give a duration of 14 days for the Home Office to come back with a decision. And if they have
Mhm.
not done so, that means that the applicant or the person who wants to issue JR can then go forward to lodge permission for JR with the upper tribunal. And they, of course, would be looking that this application is brought 90 days plus one from the time the person received a decision a decision to refuse their application. So of
Okay.
course, you will have to pay the court fee for judicial review, and you will also have to pay for the legal fees as well. And most of the time, these applications are done with the evidence that was provided, and then you also have skeleton arguments in terms of why the court should give permission. And so once those skeleton arguments have been made, or those grounds have been put forward why permission should be given for the judicial review, then of course the court will take its time, have a look, and if they believe that permission should be granted for judicial review, they will notify the solicitors, and then of course give a date for a hearing. And that is when of course the Home Office will look to see if they can review their decision. And because it's an expensive process, they would usually reconsider, and so they will always give a consent order and ask for a consent order to be signed, something which you would usually say, if a decision is reviewed and they still would go by the previous decision that they made, they would then grant this person a right of appeal, or they would refund or pay the cost of the judicial review claim that was brought forward. And so there's always some sort of consent order that they would agree to before the court goes ahead to make a final decision on it. And so it's another remedy for those who may not have a right of appeal and may think, maybe I want a third party like the tribunal to have a look at my case, because maybe the Home Office, they are not going to make a decision in my favor, and I know that everything that I presented was genuine, for instance, and so I want the tribunal to have a look at it. And so yes, most of the time, if you don't have a right of appeal, or you even have a right to administrative review, and you think the Home Office will not favor you, then you would of course have your redress by applying for judicial review. And so yes, a lot of people, even if after you have a right of appeal, I'm not saying that those who have a right of appeal can never apply for judicial review, but if you have exhausted your right of appeal and genuinely there are grounds to say that the Home Office or any public authority has made a decision which is not lawful in any way or form, then of course you would go ahead to apply for permission to have your case taken on by judicial review. Yes.
Tom is asking, is there a time limit on the time a judicial review could be asked for, even if after 10 years?
Mm-hmm.
Is there a time?
So, yes. So, like I was saying, if the Home Office made a decision to refuse, and then you then decided to draft a pre-action protocol letter, which is what I said was like a warning to them that you're going to bring a judicial review, that permission has to be brought 90 days plus one from the time the Home Office refused your decision. So the time period is 90 days plus one.
90 days plus one.
Yes.
Okay. Brilliant. Ladies and gentlemen, if you've just joined us, this is Heritage TV. Hanging out with Vicky with BWF Solicitors. Today we are discussing what do I do when an application is refused, with administrative reviews, appeals, and judicial reviews. With me is our seasoned solicitor and a partner, BWF Solicitors, Mrs. Eunice Achampong. She's here to, delve into the topic and answer questions on this topic. If you'd like to contribute or ask any questions, please do so on all our social media handles, and we'll be able to, pick the question up and Lawyer Eunice will do justice to the question. If you prefer calling me live on this program, the number is 0744 8619711. It's 0744 8619711. You could also send me a WhatsApp question, and I'll still be able to pick it up and pass it on to Lawyer Eunice. I also entreat all of you to please share this program and for other people to also benefit from this program. Lawyer Eunice, yes, I've got a question that's just come in. It's quite a lengthy one. Right. 2 years ago, I put in a spouse application for 5 years residence card, and it was refused. I then submitted another application under the EU settlement scheme, and it was refused about a month ago because they didn't believe my customary marriage certificate was valid. I have put in an appeal, but I was thinking if I had seen a lawyer to do the application, maybe it would have been successful. What do you say, Lawyer Eunice?
So, of course, usually if an application has been refused once before and you think that it was for something that, of course, you could handle yourself, and therefore you put in another application and then it's refused again. Usually the case is the first time it was refused. If you had sought legal advice, maybe you wouldn't have had to have the application refused again. So if, of course, you had taken it first time round to seek legal advice, maybe the time period would have been cut a bit shorter in that case. So now he's said he's done a right of appeal. So he's exercised that right of appeal, and hopefully on whichever basis it was refused, I'm hoping that he now has legal representation, and of course, they can obviously make the grounds for which they believe that he should be granted a spousal, leave to remain, rather than it being refused again. In this scenario, of course, if you were refused because of a customary marriage certificate, a lot of country nationals have their own laws in regards to customary marriage. But here in the UK, we know that, of course, when you look at customary marriage, one of the cases that we all look to is NA Brazil, and the fact that in that case, once you have shown, for instance, that the marriage was done by proxy, and so proxy means that you were not there, but then other family members or other people were able to make or register the marriage on your behalf, or have the ceremony done on your behalf. And so in a case like that, where the courts and also the Home Office have now come to the agreement that obviously customary marriages can also be seen as valid here in the UK, then it will depend on whether it was done according to the law of that country. So if your customary marriage followed the procedure and the legal procedure that is available in your country, and you can correctly explain that it has gone through that process and is legally binding in your country, then of course you present that evidence to the court during your appeal. And that may require a good solicitor who is able to look at that country's law in regards to customary marriages and how best your marriage certificate meets the requirements. And therefore, if your marriage certificate meets those requirements, then it should be seen as valid here in the UK. So, of course, once he's sought legal representation and the evidence is provided to the court and to the Home Office representatives as well, he should be fine.
Okay. All right. Yes. Alajis also sent this question. Dear lawyer, please, I submitted an application for my wife to join me in the UK last year. I have indefinite leave to remain and met all the requirements. About 3 months ago, they sent an email that they wanted to interview us. I could not make it for that date they gave us because I had to travel. They scheduled another date and called us on the phone to interview me and my wife separately. About 2 weeks ago, they brought a refusal decision based on the interview answers we gave. Would it be better to do a paper appeal or have an oral hearing?
So in this scenario, obviously he's
No,
saying that
yes, first
him.
of all, how can they refuse? How can they refuse someone because interviewing husband and wife they weren't convinced? How?
Usually that happens when they are suspicious or they do not believe that the relationship is genuine. So one of the ways that they can, should I say that a relationship is not genuine is if they have conducted something like an interview, because they need
Right.
some sort of evidence to say that they have therefore got enough evidence to say that it is more likely than not that this marriage is not a genuine marriage. And so, of course, the Home Office likes to use a lot of interviews to then say, do you know what? After carrying out this interview, we believe that this marriage is more likely than not to be a non-genuine marriage, and therefore we refuse the application. And
Without
one
giving
of the
details, whether you had
well, they'll
five
tell
out
you
of
that you had
10
a lot
questions
of
right.
inconsistent answers. So that's one of the things they would obviously say, because they would have the transcript of the interview and everything that
Yeah.
you said and everything your spouse said and what you didn't say right and what your spouse didn't say right. So they will obviously highlight the bits where you had it wrong, or your spouse had it wrong, and they'll present that as evidence to say that they believe that it's more
Okay.
likely than not you are not in a genuine marriage. And so of course they don't take lightly to sham marriages, or they don't take lightly to marriages of convenience. And so
Yes. Yeah.
in this person's case, of course, if they have conducted an interview and based on the responses that they gave, they think that it is more likely than not that they are not in a genuine relationship, which one of the requirements under the immigration rules is that you should be in a genuine and subsisting relationship. And so if he or his wife gave inconsistent answers to a particular question, for instance, that was given, then they are going to stand on that to say that he is somebody who they don't believe, or she is somebody they don't seem to believe to be in a genuine marriage. And so, coming back to the question of this gentleman and the fact that he's been refused and he wants to go ahead and, of course, have this decision appealed. Of course,
Mhm.
the only way forward is to have it done by an oral hearing. If
All right.
you are going to do it by paper, and you think that on paper you're going to answer all these questions correctly, so that the judge will just look at it and say, okay, on paper you've explained and you've tried to answer I'm sorry, but the judge is going to look at the answers that you've put down and said and say, do you know what, you've tried to manufacture something just for me to look on paper, and that is likely to be refused, because you want the judge to be able to give you some attention. And of course, a lot of the things that you say whilst you are at a hearing will be then, should I say, cross-examined by the person who is representing the Home Office. So your representative is going to ask you questions. The Home Office representative will also ask you their questions. And if the judge is not clear about something, he or she may also ask you further questions just to clarify their mind about whatever you said. And sometimes it may be that language is a barrier. And so if you were interviewed in English and your English is not so good, and through a hearing you are likely to ask for an interpreter, then it means that, of course, you have the best chance, because now an interpreter is going to express what you were trying to say in the best possible way. And I don't think everybody knows their spouses in and out 100%. I think that the most realistic scenarios, people would not get everything correct. And I
Yes.
could probably go
Yes.
for an interview with my husband, and there could be a lot of inconsistent answers. But that doesn't mean that we are not a genuine couple. It just goes to show that in a normal relationship or in a normal home, there are certain information that may not be relevant to one party and the other party may see it as relevant. And so, of course, this is what usually happens in a real life relationship, and judges know that. And so the Home Office know that this is not always the situation in real life. And so it's always good to go and present yourself at the hearing and then present a realistic view of your relationship, so that the judge looks at you and says, okay, at least you may not have answered everything correctly, but I can see the genuineness in the responses that you gave. And to my assessment, I believe that your marriage or your relationship is genuine. And so a lot of the time, I think that, of course, a third party view is always better in cases like this, rather than going back, for instance, to have a fresh application done. And paper applications, they help with things where, for instance, you are saying that maybe the signature was different on the marriage certificate to the the passport signature. So
Okay.
maybe it might help to explain why the signature was different if, for instance, you were doing a paper application. But when it comes to things so serious like a marriage being uh, being said is not genuine, then I would say definitely it helps for you to have an oral hearing, so that the court and the judge himself can make a proper assessment to things like your body language and how your response was to that question that was given, and how your spouse also responded in terms of the statement that was given and the rest of it. So it helps in those scenarios that even where an interpreter is needed, they can better communicate your answers, rather than relying on the English that you may not be so effective in communicating. So things like an oral hearing always help.
Great. Great. Um, Bumi. Hi, Bumi. And she says she loves our show. I recently submitted an application for a visit visa to see my sister who is unwell. I have visited her once before, but for some reason, this application was refused on the basis that there were monies which showed on my bank statements that were not explained. I provided to them all the relevant documents and do not know what to do. What do I what do I go about getting them to issue me the visit visa?
So of course, this is to do with somebody who is asking, do you know what? I've done everything possible for them to issue me a visa, and she's made it clear that this is not her first time making the
Yeah.
application for a visa. So that's a good thing. So of course, if you've previously been granted visa and you are reapplying for another visa to come and see your sister, usually the familial relationship that you have is also seen under Article A as a right to family life. And so, if her sister here hasn't got any other family members here in the UK, and she is the only sister that she has outside of the UK, then of course it will be good to show that family tie or that family relationship that they have with each other. I know that she's saying that they refused it because they said they don't believe um, there are certain transactions on her bank statements which she didn't provide evidence for, and she's saying that she did provide all the documents, so she doesn't know why it's being refused. Of course, somebody would say just reapply, but then what, on what basis are you arguing that
You're
you
not, yeah.
made this application and you provided everything to them and they are still refusing it? And so it will always have that question mark, and you don't know whether it will be refused again. That's another thing with reapplying. And of course,
Okay.
if it's refused again, then what is the remedy? Are you always going to go back and forth with them? And most visa applications do not carry a right of appeal. So, of course, if you are looking to have some resolution or you're looking to have some form of remedy, then it would mean that you have to exercise your right to judicial review. And of course, when we say judicial review, we want to say that the decision that they have made is unlawful, and you have to look at what the lawfulness is. And so, is it lawful for them to grant visa just because you want to come to the UK to see your sister, or is there a particular reason why it is unlawful? And usually a legal representative will be able to help you understand why their decision is unlawful. And first of all, of course, if she's saying that that is her sister and the sister hasn't got any other family relations here in the UK, for instance, and she is the only family member, then that would mean that, of course, there should be some strong family ties that she has with her sister. And that could be evidenced through the fact that they are always communicating. For instance, maybe they're always emailing each other or sending each other messages, or they phone each other to find out how they are doing and the rest of it. And so, in a case like this, if you are saying that you have that strong familial link, then it means that this decision is infringing upon your right to have family life with your sister. And therefore, in that sense, when her sister is not well and is in need of her, it means that the Home Office has basically made a decision which is preventing her from seeing her sister, who she has that strong familial link with. And of course, once you're able to see a solicitor or a legal representative in that regard, then they can obviously help you to obviously draft a pre-action protocol letter, and then have that sorted through the Home Office responding, or if they still do not give a favorable response, then judicial review can be issued. And so, of course, if there is no right of appeal, the remedy will be to issue permission for judicial review. And unfortunately, most visa applications do not carry a right to have administrative review. So that's also one of the things, because administrative review is only available to certain types of decisions as well, and it's not available to every decision that the Home Office will make. And so where there is no redress, we don't have administrative review, you don't have right of appeal, then the only other remedy will be to see if there has been some unlawfulness in their decision and therefore go on to issue permission for judicial review. And all of this will definitely need the help of a legal representative. So if you find yourself in such a situation, then do seek legal advice.
Okay. Right. So I think I've exhausted all my questions from viewers. If you have any questions from your end on the BWF platform.
Okay. So I think this is Jabansi. It says, I didn't receive my BRC. I'm guessing this is her biometric card after the courier would have supposedly delivered it. I sent a letter to the competent office. What do I need to expect now? Are they going to reply back, and how long is it going to take to get the card? So usually if you haven't received your BRP and you go onto their website, so if you say BRP not delivered, it will allow you to fill an online form or an online application. So once you have completed the BRP not arrived form, they will send you an email as soon as the form is completed to let you know that the submission has been made. And then usually will tell you that they would respond within 20 working days. And so, of course, within that 20 working days, you would expect that they will respond to let you know that the card is being issued, or we tried to deliver the card and unfortunately you were not available. And of course you can, then they would give you the contact for the courier service to be able to also email them and then let them know the correct address for them to resend the card to. So I'm not sure where she sent her letter to, but usually it's an online form that you fill and then they get back to you. And if the TNT does send an email, you can email them back and they will let you know when the next delivery can be made.
Okay. All right. So in the absence of any further questions, I think we have to unfortunately coming to the end of today's interesting program. I would like to take this opportunity to thank all of you who stayed with us throughout the program. We very much appreciate your presence. I would also like to say thank you to Mrs. Unisa Champong, always coming our way every Saturday. I would also like to take this opportunity to also sympathize with those Afghanistan residents in the UK who have got families back home in Afghanistan and are going through a lot of emotional, pain, not knowing what will happen to their families. In the beginning of the program, myself and Lawyer Eunice touched a little bit on that. She said a lot, and we believe that there is hope for those who are residents in the UK and have got family back home in Afghanistan. If you need any help, I think Lawyer Eunice, if I'm right, anybody who is going through this, can they contact you for any advice and help as well?
Yes, and so obviously the best thing to do will be to also redirect them to the support that the British consulate in their country is also giving. And so they can contact me and then I will point them to the right direction. My number is 075 35 81 3910. So 075 35 81 3910.
Okay. All right. So so that is it. We very much on behalf of myself, the team at Heritage TV, Lawyer Eunice and her team, we do sympathize with all of you. As Lawyer Eunice indicated, she's there to support and direct you to where to go for help. Anything she can do to help, she will be available to do that. I'll also say a big thank you to our sponsors, BWF Solicitors, Victon Estates, and Eagle Heights International School. May I also inform you that Heritage TV is a big media house. They have packages for those who are organizing parties, weddings, church functions. Heritage TV, will be able to cover all your functions live. If you want us to also broadcast your occasion live, we will also be able to do that, making that occasion a very memorable one. So please do get in touch with the team at Heritage TV. If you have any upcoming events, our media team are on the standby to come make it a very special day for you. Lawyer Eunice, if anybody watching wants to get in touch with you regarding any immigration issue, aside what we discussed today about administrative review, appeals, and judicial reviews, anything else regarding immigration, could you please give us your contact details, office address, for them to get in touch with you?
Okay, so as you mentioned before, I work with BWF Solicitors and we are situated in London. Our address is the 4th floor of Anna House. So 4th floor of Anna House, 214 to 218 Tottenham High Road. And we are in London, as I said, Seven Sisters. Our postcode is N154NP. So N154NP. Our offices are open from Monday to Friday from 9:30 a.m. to 6 p.m. And we usually take appointments throughout the week. And of course, if you wanted a Saturday appointment, for instance, you will have to call in and see what our availability is like. So the office number to call is 0208 493 7340. So 0208 493 7340. So, of course, I know there are people who are still asking questions on the platform. And so if you want to speak to me after the program as well, my number is 075 35 813910.
Thank you so much. So on behalf of myself and Lawyer Eunice, we would wish you a wonderful weekend, and hopefully we'll see you same time next week with another interesting topic, for us to educate ourselves and also help our community regarding any immigration issues. So I think between myself and Lawyer Eunice, as we always do every Saturday, we end this show with a lovely wave and smile. Bye, and see you next week. Take care.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law, At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stock repossession, and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.